The defense attorney yells out, "I object. Do not answer that question," he says to his witness during a deposition. Can he legally do that? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. All right, during a deposition, which is a question and answer session given under oath, it's pretrial testimony that's typically given in an attorney's office. There's a court stenographer there, or court reporter, to take down all the questions and answers that are given. There are instances where a defense attorney will turn around to their witness and say, "I object, do not answer that question. I'm directing the witness not to answer the question." Can the defense lawyer legally do that? The answer is there are only two instances where a defense attorney can legally do that. In almost every instance, the lawyer cannot, under any circumstance, do that. And the only two instances that they can tell their witness not to answer the question is if the information that we are asking the witness is privileged, meaning, "Hey, Mr. Jones, can you tell me what you talked to your attorney about before we started questioning this morning?" That's privileged information, and I cannot ask that question, and I cannot gain information from the witness about that particular conversation. The other time the defense attorney would be fully within his right to tell the witness not to answer the question is if my question was palpably improper and had absolutely nothing to do with the claims or the defenses being made in this case. So, for example, assuming it's a medical malpractice case and I'm questioning a doctor, if I turned around and asked the doctor, "Doctor, how many times do you beat your wife at night?" "Objection, palpably improper, don't answer the question," is what the defense attorney would have a right to say. But in every other situation, if it is not a privileged question and it's not a palpably improper question, the witness must answer every single question that I'm asking relating to the claims, relating to the issues involved, relating to the facts of the case. And there's a key reason for that. The court wants discovery, that's questions and answers, to go forward. And if there are objections, the defense attorney will make his objections and the witness still is required to then answer it. Only at trial, now when I ask the witness similar questions and the attorney objects, will the judge make a ruling on whether or not those questions and those answers are appropriate. So during the course of pretrial testimony, the witness must answer every single question unless it is palpably improper or it calls for privileged communication between the attorney and the witness. So why do I share this great information with you? I share it with you just to give you an insight and an understanding to what goes on in the litigation process, especially the pretrial litigation process in the state of New York. Yet I realize you're watching this because you have questions or concerns about your own matter, whether it's an accident case, whether it's a medical malpractice case, or even a wrongful death matter. Well, if your matter happened in the state of New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. Well, that's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.